For more on these legal stories, lawyer and Arise News analyst Frank Tietie, as well as the senior advocate of Nigeria, Kunle Adegoke, joins us now on the news. Well, let's start. Thank you so much, gentlemen. Let's start with you, Frank. Thank you for sparing us time to be here. I think a good place to begin will be the court here in Abuja in the case of Governor Ben Ayade of Cross River. The court today took a leave from the Court of Appeal judgment, which refused to sack Governor Umahi of Ebonyi State. It looks like defection of political office holders is here to stay with us. What do you think?
Oh, well, thank you very much. It's not yet uhuru with regards to the issue of defection in Nigeria. The court, particularly in this case, has agreed that defection by a governor to a party that didn't win an election is wrong. But the court should not be lame. The court should not be so impotent to the extent of realizing that something is wrong without also giving the consequences of that wrong action. So that is not part of our jurisprudence, to think that the court will just sheepishly follow, the principle of stare decisis. That is, it must follow a decision that has been given by the upper court, considering that there are reasons for distinguishing it. So the court should have been a bit more explicit and be courageous enough, like the case of Justice Inyang Eko, who made up his mind and said this is what he thinks as a judge, because in situations where there are gaps in the law, that becomes the role of the judiciary to fill such gaps by making law, actually. So to think that the judiciary does not make law, that's not the real situation. The judiciary does make law. The executive, that is the presidency or ministers of government, do make laws. And then the judges, or the members of the National Assembly does have the primary responsibility of making laws. So the business of government is about making laws and enforcing laws. So that court should have been courageous enough to state its mind.
Justice Taiwo is actually arguing that the National Assembly should actually make it a bit more clearer. Well, Barrister Frank Tietie, we'll come back to you. Let's go to Kunle right now, and let's talk about the fact that some lawyers like yourself are of the opinion that there is a conflict in law or conflict of law here, because if we remember, the Supreme Court had ruled prior that, any votes that a candidate garners actually belongs to the party. And now we're seeing a Justice Taiwo say, you know what, a governor cannot be removed based on the fact that he defected. So if we actually want to get it right, how can we actually balance this? And do you think it's something that we should consider taking up to the Supreme Court to have it resolved, so we're clear on what should be done?
Thank you very much. The position of the law on this issue is quite very clear. The Supreme Court has been quite categorical with the decision of Attorney General of the Federation and Atiku Abubakar, which was decided in 2007, to the effect that defection from a political party in which a governor or deputy governor, president or vice president was elected will not be a ground for such a governor or deputy governor to vacate his seat. The provisions of the Constitution are quite very clear when it comes to the ground upon which a governor can be removed from office. That is different from a situation where we are considering a member of the National Assembly or State House of Assembly, whereas a legislator may be removed, may have to vacate his seat if he defects from the political party on which he was elected onto another political party while serving in office. That is quite clear, and that decision by the Supreme Court in Attorney General of the Federation and Atiku Abubakar has not been set aside. All lower courts are bound to follow that decision in situations quite similar to that, or on all force with that. And the situation we have right now in the case of Umahi of Ebonyi and Ayade of Cross River is exactly what we have in AG Federation and Atiku Abubakar. The Court of Appeal in Enugu, Justice Olubunmi Oyewole, has recently held, just about a few days ago, that it will not be a ground for a governor to vacate his seat where he defects from the political party where he was elected to another political party. The Constitution is quite clear on that, and it is not for the court to say they are filling in the gap left by the Constitution. It is unheard of for a lawyer to come and even advance such an argument. I mean, definitely it's not consistent with what we have known to be the position of the law. And that is why the Court of Appeal did not agree with that position as recently canvassed in the case of Ebonyi. It may be immoral, just as stated by the Supreme Court. It might be unfair, but the Constitution has stated clearly circumstances in which a governor, deputy governor, president or vice president will have to vacate his office. Now, constitutional amendment is ongoing. If we disagree with this position, the best way to go is to make sure that the legislature, the National Assembly, will amend the Constitution to provide for a situation where a governor may have to vacate his political party. In the absence of that, there is nothing anybody can do about it.
In fact, I wonder if you agree absolutely with that, because the Constitution is also clear on the qualifications of a candidate to include that you must be a member of a political party, and that political party must sponsor you. So when you defect, should you still remain on that seat as a governor who was elected and sponsored by a political party which you have now left? It's a lot of confusion. But beyond all of this, is there a portion of this blame that should go to the political parties themselves?
Not at all. I think it's about dignity. It's about being consistent with
the morality of it.
And the court, no doubt, the present court decision on Governor Ayade made it clear that it was agreed with the PDP's lawyer that it was absolutely wrong for a governor to defect, having taken votes from a political party that won the election to another political party that did not win. The point is that Justice Nyagweko, his decision is yet to be subjected to appeal. This court had is hand tied because it felt that a court of appeal had already, in April 1, had already made a decision regarding Umahi's case, and the judge didn't want to go further to making his own decision, but relying on the principle of stare decisis. Oh, there is no doubt about the fact that the judiciary ought to live up to the social development, the times and tendencies. The judiciary cannot be tied when the generality of the population believes that something is wrong, yet it claims that its hands are tied because of lack of statutory provision.
Right, and you know what, at the end of the day, interesting times we are in, gentlemen, you must agree, because tomorrow the Federal High Court will actually pass its own judgment as it concerns the Zamfara State Governor. Remember that back in 2019, the Supreme Court had said that the APC had no candidate, and of course now they have a sitting governor. But looking at the fact that we're seeing courts of coordinate jurisdictions with different judgments, talking about Ekwo and Taiwo today, Kule, this question is to you. To deepen our jurisprudence, how should we be handling this? And who should be championing, making sure that we have a level playing ground and we have a set rules as to how we come up with certain judgments as it concerns matters that are similar to each other?
Well, you see that in the case of the decision of Justice Ekwo, that one was decided about a month or so ago. And that was before the decision of the Court of Appeal, Enugu Division, that was handed down just last week in the case of Umahi's case. And the decision of the Court of Appeal recently handed down. Probably if it had come before Justice Ekwo's decision, his lordship would have probably felt much bound by that decision, more so that it is so recent and it's interpreting the same provisions of the Constitution that Justice Ekwo was confronted with. But since that decision of the Court of Appeal came after Justice Ekwo's decision, then we may say that, okay, probably if his lordship had the benefits of seeing the decision of the Court of Appeal ahead, his lordship wouldn't have followed the line his lordship followed. But in the case of Justice Taiwo, in fact, Justice Taiwo had to wait for the decision of the Court of Appeal that was about coming up. And when that decision came up late last week, Justice Taiwo felt that, look, with this decision, recent decision of the Court of Appeal, few days before Justice Taiwo's own, it would be irresponsible and it would be judicial recklessness on the part of my Lord Justice Taiwo to have deviated from a more recent decision of the Court of Appeal, interpreting the same provision. And that is why his lordship followed the decision in the Umahi's case as decided by the Court of Appeal, Enugu Division. So I'm of the opinion that Justice Taiwo hasn't done any violence to the decision of Justice Ekwo, only to the extent that where there is a decision of a superior court and it is interpreting the same provision, the lower court must follow the decision of that superior court. It's a question of stare decisis. Otherwise, there will be confusion if the High Court in Abuja should feel bound by the decision of his fellow judge of the same Federal High Court. When there is a superior decision of the Court of Appeal, it will throw the whole judicial system into anarchy, which is not right for the system.
Well, there are a lot of concerns, especially as we're going into an election year, about what this means for our political structure. But let's move on, because it was a busy day in the courts today. Federal High Court has now decided to introduce a new practice direction for the trial of terrorism-related cases in the country, especially in the case of Nnamdi Kanu, the leader of the group IPOB. Let me come to you, Frank Tietie. Is there wisdom in this decision to make this a secret trial?
Well, I think the new practice direction was absolutely unnecessary. It also indicts the government to the extent that we have become so insecure, to the extent that there can no longer be a guarantee for trial of terrorist suspects to be conducted in public. It's a fundamental requirement of the Constitution under Section 36, subsection 3 and 4, that trials must be held in public. And we're a country currently being traumatized by insecurity and terrorism, and we are yet to recover from the inappropriate application of the law in the case of Mohammed Yusuf, which led to Boko Haram. There is a strong necessity for justice to be seen to be done, and then to shut out the media and to shut out the public from the trial of an important figure like Nnamdi Kanu is an invitation to trouble. It seems as if some people delight in creating problems while others are fighting so hard to solve those problems. What does it take when we apply a measure of transitional justice to ensure that the trial of Nnamdi Kanu, for example, is transparent, is fair? This country has made much progress to the extent that the National Judicial Council has been convinced by an NGO that even television cameras should go to the court to witness trials live and broadcast such proceedings live to the Nigerian public. We saw that in the case of Oscar Pistorius. So what's going on? So what's the fear? Now, that should have been an application made by the federal government before the judge handling the trial, advancing reasons why there should be, the trial should be in secret. But to think that the court on its own would just make practice directions as if it had some intelligence that was not known to the other party, I think it's an invitation to trouble. It's unnecessary.
Well, Frank Tietie says it's an invitation to trouble. Well, Kunle, let me come back to you briefly, because we're almost out of time. Do you think there's any merit to this new process that the court is trying to introduce? Briefly, as we wrap this up.
Well, the practice direction is not so new if we are going to look at the legal regime. If you look at Section 36(4) itself, it provides for certain circumstances in which a criminal trial may be held in secret, in camera. And to that extent, we have other provisions of the law. For instance, Section 259 of the Abolition of Criminal Justice Act relating to having to conduct certain trials in secret. And this creates an exception to, that is, all trials must be in public, but there are certain exceptions, which would include maybe offenses relating to terrorism, relating to economic and financial crimes act and what act. And in such a situation, the court may conduct such a trial, excluding the members of the public. However, in the current case of Nnamdi Kanu, I do not personally subscribe to the idea of the secret trial. I don't know what intelligence the government may have, but I do not think it's the appropriate way to go. For instance, there hasn't been it has not been shown that there is any threat to public security, defense, or whatever, strictly speaking. And in such a circumstance, we do not need to create an avenue for which people may think that if it were to be some other person's, such trial would have been held in public, allowing camera to cover it and what have you. A trial of this nature is so fundamental to the determination of how just the court proceedings is, and it's on that basis that we need to conduct trials of this nature, actually allowing the journalists to cover it and protect, because
it's always been a tense trial looking at Nnamdi Kanu, the leader of the indigenous people of Biafra. But gentlemen, we'd have to say thank you to you, Frank Tietie, Arise News analyst, as well as Kunle Adegoke, senior advocate of Nigeria. Thank you, gentlemen.